Okay, so just to recap what we've done, we did the preamble, and then we've done the first uh, the first three articles of the Constitution, covering the three branches of government. So now we're moving into a little bit more of the function, I guess you could say, and not so much structure, but uh, this part of the Constitution really answers questions in a federal government, and we'll get into what sets the stage for that. But Article 4 deals with relations among the states, um, and so you've got a couple of big things here on Article 4. One is called the Full Faith and Credit Clause, and the other is the Privileges and Immunities Clause. And I will say this, with both of these, there are sometimes disagreements between states. Um, and in some cases, you've had states can sue other states. If that happens, it goes typically, I think, goes directly to the Supreme Court, and where the Supreme Court actually sits as a trial court rather than as a court of appeal. In other words, they have an original jurisdiction rather than appeals or appellate jurisdiction. But the first one there is, basically says the states are to treat each other as equals. And we get this from the Full Faith and Credit Clause. Each state must recognize the validity of laws, public records, and court decisions of every other state. And I will say this, the trend in the last probably 50 years has been more to recognize court decisions, but you've seen more challenges to the validity of laws. And so when you see that, it really does kind of play into, or can play into, the Privileges and Immunities Clause, and we'll get to that. But sometimes when you have states that deal with, they've passed laws that deal with fairly controversial subjects. In the last 10 years, we've had laws that began in states and then ultimately got nationalized by the Supreme Court, things such as gay marriage. But if you look at other pretty controversial subjects like abortion, even capital punishment, which is putting someone to death for a guilty verdict for murder, those kinds of things sometimes do crop up. But most of the time, both of these things work really well. They do what they're supposed to do, but it's not to say that there's not problems with it. So each state must recognize the validity of laws, public records, and court decisions of every other state. So if my wife and I, we were married in Oklahoma, but we moved to another state, we don't have to get married again. Nor would a divorced couple have to get divorced again if they moved out of state. Those decisions are recognized by the other states. And that goes with, it's going to lend itself to the last little thing that we'll talk about here, which is basically extradition, and we'll get into that in just a second. So part 2 of this is what we call the Privileges and Immunities Clause. Citizens in one state are entitled to citizenship in any other state. So it's not like a collection of countries. We are all one country, so we have freedom of mobility. We don't have to pay a fine or a tax to move out of state. We don't have to pay fines or taxes to travel through other states. We have freedom of mobility. And that basically boils down to the fact that states cannot discriminate against residents of other states. And I will say this, there is, obviously, we live in strange times, and I came across a case that's been brought to federal court out of North Carolina, where you have a number of residents that have joined a class action lawsuit against the state of North Carolina. These residents live in the they own homes in the Outer Banks. So we're talking on the coastline. And they have been not allowed to travel to their homes during the pandemic. And so they are suing in federal court to try to get the state of North Carolina to lift um, that that rule, basically that law. So there are times when these things can be challenged. And basically, North Carolina is saying, these people don't live here; they have vacation homes here. We can't account for their safety. But they, the citizens that brought the class action lawsuit are arguing that those are our homes, and under this, you can't discriminate against us. So it'll be interesting to find out what happens. The last little bit here is something called extradition. So extradition basically just means a person charged with a crime in one state who flees from justice to another state shall be delivered back to that state having jurisdiction. And again, just like the other two, this usually works flawlessly. But there are times when you've got, when it comes down to going back to the full faith and credit clause, when you've got one state that's got a fairly controversial law regarding something like capital punishment on the books. I can remember when I was in high school, there was a person that had been accused of murder in one state and fled to another state that did not use the death penalty. And so they were basically protecting him from extradition back to the original state where there was a death penalty. And ultimately, it ended up working out. The state that had the death penalty was able to force the federal government's hand and basically get involved and make that state return the accused person back to the state that had the death penalty. But the only other time I've ever remembered this getting somewhat confusing was it was actually a case that began in Oklahoma. A guy went on a killing spree and went from Oklahoma to Arkansas to Missouri and then I believe up into Iowa and killed people on this killing spree in all 4 states or 5 states. And so ultimately Oklahoma got to try this person, this individual first. The crime spree began in Oklahoma, so the original jurisdiction for that crime spree was brought back to Oklahoma. He stood trial, he was found guilty, and he was executed in Oklahoma. And then lastly, the federal government is responsible for protecting the states and its citizens. And this goes back to, it's going to lend itself to what we call the Supremacy Clause, which we'll get to in just a minute. But we typically think of that as just the umbrella of law, but it is also the umbrella of protection. So one way to think about this, and probably the easiest way to think about this, is that an attack on one state is an attack on the United States, if that makes sense. So the perfect example of that would be something like 9/11, the attacks on the World Trade Centers in New York, and the attack on the Pentagon. Those were acts we determined to be by a terrorist group against the United States, not just against a state or a city. So the other part of Article 4 that we'll talk about is how we create new states. This hasn't been done in a long time, since just after World War II. The last 2 states that Congress created and the President signed off on was Hawaii and Alaska. And so how do we do it? If you think back to Oklahoma statehood, we were admitted through an act of admission in 1907. And so how does this happen? Typically a territory they're going to file a petition for statehood, and they have to do a few things. So step number 2 is that the president would approve a congressional resolution for the territory to write a state constitution. And if you think back to, we've mentioned the Supremacy Clause, we haven't gotten into it yet, but the state constitution, any state constitution, whether or not it is from a territory, a proposed statehood, or from an actual state, nothing in that constitution can be in contrast or contrary to the United States Constitution. So this approval is what we would call an enabling act. And then the third piece of this is that Congress and the President would approve the state constitution and the territory would then become a state. At that point, the state would then hold their elections of officers and the put a lot of the pieces together to actually form a government. Most state governments um, mirror our federal government. In other words, most state governments, not all, have a state governments that's composed of three branches and have constitutions that I would say that are similar to the United States Constitution in terms of how they set up their government, how they pass laws, how they create revenue for their state, etc. So Article 5, and remember there are just 7 articles. So Article 5 deals with how can we change the Constitution. And I will tell you this, they made it hard, they made it difficult, and they made it difficult for a reason. They wanted, if we did change the wording of the Constitution through a formal amendment, they wanted it to be sure. And so there are basically 4 ways a constitution or an amendment can be proposed and ratified. 2 forms of proposal, 2 forms of ratification. The first formal proposal method is by 2/3 of the House of Representatives and 2/3 of the Senate. Or you could have a 2/3 majority of the states that propose at a national convention that's called by Congress. And then the other piece of this is ratification. So the proposal comes from either Congress or it comes from the states. And then the ratification, which is the acceptance or the passing of that amendment, it has to be ratified by one of these 2 methods, either by 3/4 of the state legislatures or by 3/4 of the states at state-held conventions. So you can see there's 4 possible ways an amendment could find its way into the Constitution. Now, going back to the difficulty of it, we're getting ready to talk about that. We've only formally changed the Constitution 27 times. We have 27 amendments to the Constitution. So the Founding Fathers wanted it difficult, and it is difficult. It's difficult to get those kinds of majorities behind an idea. And I would argue in today's world, as divided as we are politically, it would be next to impossible. Sometimes a crisis can invoke an amendment. So, we talked a little bit the other day about the assassination of Kennedy. We talked about the 4 elections of Franklin Roosevelt. Those kinds of things can get the ball rolling for an amendment when people see what, if there's a detriment to the way we had been doing something. But I would tell you, as your government teacher, or at least one of your government teachers right now, it should be hard. American society, in terms of their public opinion, can be quite fickle. In other words, it changes frequently. And we don't want, we don't want that kind of change in our Constitution. We want it to be slow and steady and sure. So, as I alluded to earlier, we've touched on this, but you need to know that it is in writing in the Constitution. Article 6 deals with federalism. In our brand of it, you have a stronger national government, followed by the subordinate state governments. So if you look at the wording of this is what we call the Supremacy Clause, the supremacy of the Constitution. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So, to put that into perspective, what that really means is that obviously we consider the Constitution to be the backbone of all federal law, but the Supremacy Clause calls for the Constitution, all federal law, all treaties that are entered into by the United States. Those are all, they supersede or they are supreme to any other law in our country. So you can't make a law as a state, as a county, as a city. You cannot make a law that is contrary or goes against anything above it, which would include not just the Constitution, but federal law and treaties. That's what the Supremacy Clause means. And then lastly, we have ratification. And I told you earlier, ratification just means to accept, to confirm. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. And this was when there were ultimately going to be 13 states, or there were 13 states. So, and that's what we've lived with since, and that's a pretty impressive document when you think of. And I will tell you this: there are always going to be challenges to it. I would argue that. Our democracy is not as stable as everybody thinks it is. It's more fragile than what people think it is. There are challenges to it all the time, and that can be in terms of federal law. It could be even from court rulings, and that's kind of our job as citizens, is to guard against it. And the way we provoke change in our country is by voting, by becoming politically active, even at the most minimal level, which is casting a vote that protects our country.